Well, good morning, ladies and gentlemen.
Good morning.
Welcome to our symposium here at the National Press Club in Washington, D.C. I'm Bob Scholes, chairman of the We the People Foundation for Constitutional Education, which is a not-for-profit organization based in northern New York, dedicated to research and education about matters of governance. This, as you know, is the fourth conference we've held here in the past 12 months to examine the issues of illegal operations of the federal income tax system and the IRS. This is the symposium that explains the true meaning of the words tax fraud and evasion. While the government is out there investigating and prosecuting citizens on charges of tax fraud and evasion, we've been investigating and charging that same government with real income tax fraud and evasion of questions and allegations regarding the legality of the tax operations. The allegations have been framed by us for debate in terms of four propositions. First, that the 16th Amendment to the U.S. Constitution, the so-called Income Tax Amendment, was fraudulently proclaimed to be ratified in 1913, when in fact it has been shown by exhaustive research in the state and national archives that it did not even come close to being legally approved by the required number of states. Two, that the income tax is voluntary, as there is no statute or regulation that requires most citizens to file and pay federal income taxes or to have those taxes withheld from the money they earn. Three, that citizens cannot voluntarily file a federal income tax return without involuntarily waiving their Fifth Amendment rights under the Constitution. And fourth, the IRS routinely and systematically violates and denies citizens' constitutional rights during its administrative operating procedures. In talking about research into the fraudulent and illegal operations of the federal income tax system, we've sometimes referred to the story of the several blind men who bumped into an elephant and then got into a big argument trying to describe to each other what the beast must be like. In the matter of investigating the income tax, numerous researchers have focused on various aspects of it, but what their writings and conclusions all share in common is a description of fraud, deception, hoax, and violation of our constitutional rights in the operation of the federal income tax and the IRS. The fraud appears to be one of such an enormous scale, government's desire to keep citizens in the dark so strong, and the attempts to touch the beast so dangerous that the analogy to an elephant and blind men is very appropriate indeed. What we at the Foundation have tried to do is to help put all the descriptions together so that they can be seen as one big mosaic. To combine the work of several researchers is the only practical way to get a view of the whole picture, since it's just too large for any one individual to have done all the research on it alone. We have a pretty full lineup of speakers today, and it's very gratifying indeed. You can refer to your agendas and information in your packets for brief sketches of them. We have several new faces who will start the program talking about jury nullification of income tax failure to file prosecutions based on a lack of demonstrable evidence that there is any law or regulation that requires most citizens to file and pay income taxes. These courageous speakers are Whitey Harrell and Marcella Brooks from Illinois. We have provided you for you to look at later a handout in your packets about jury nullification. We also have two more employers who have stopped withholding taxes from their workers.
Oh, great.
Yay.
Dick Simcannon from Texas and Nick Jessen from California has stopped withholding taxes from the employees of his 3 electronic companies out there. We'll be talking to Nick Jessen by phone at 11:30. We have a hookup arranged so that we'll all be able to hear Nick and what he has to say. He will be reading his letter sent last month to the Internal Revenue Service and to the State of California State Franchise Board, his 6-page letter detailing what it is he's doing or no longer doing and why. Dick Simcanin and Nick Jessen have followed the lead of Dave Bossett from Florida, who has also come to be with us today, and they will all tell us their courageous stories. We've also rounded up the usual suspects, the accusers, as we might call them now, from our previous meetings. Bill Benson, former tax investigator from Illinois, who exposed the fraudulent ratification of the 16th Amendment 15 years ago, and who has incidentally co-authored a treatise in 1986 calling for a nationwide movement of jury nullification as a way for citizens to take control of the wrongful tax prosecutions that were ruining people's lives and sending many to jail. Joe Bannister is with us, former criminal investigator for the Internal Revenue Service, whose 2-year investigation into allegations of fraud made by several researchers resulted in his report that concluded that they were right. Bill Conklin is not with us, just simply couldn't get Bill a seat on a plane out of Denver on this holiday weekend. But Bill challenged the federal judiciary into conceding that the filing of federal income tax returns is indeed voluntary. In the court's words, non-compelled testimonial communications. Taking Bill's place here before us today and speaking will be Pat Shannon. Pat Shannon is a journalist who has recently returned from interviewing Gary Phillips, who is out of the country at the moment. And Pat will be sharing with us the results of that interview. Many of you know the story about Gary Phillips. Larry Becraft, who has defended many citizens in tax cases and challenged the judiciary with the 16th Amendment argument and was sanctioned for his efforts by judges determined to evade the issue of a fraudulent income tax. Larry's with us today. And D.V. Kidd, who has educated millions about tax issues with her booklets, radio, TV, newspaper interviews, and via her internet website. We're very delighted, very honored to have as our luncheon speaker today Mr. Edwin Vieira, renowned author and attorney whose specialty is constitutional law. And this afternoon we're fortunate to have as speakers several presidential candidates and others who have responded to our open invitation. As many of you know, we published an open invitation in the Washington Times for anyone, constitutional scholars, attorneys, journalists, presidential candidates, congressmen, anyone who has researched this issue or these issues and who has spoken out publicly on them to join us here today and speak in support or in opposition to these propositions. And so we'll have Howard Phillips and Charles Collins and Louis Ween and maybe others. All the speakers today, they come together. They represent what amounts to a multi-pronged attack upon the federal income tax system from several different angles. Jury nullification in tax cases for lack of any law making most citizens liable. Employers who stop withholding taxes from their workers for the same reason. Exposure of the fraudulent 16th Amendment and suing in state courts to nullify their ratifications. Resistance against violation of our Fifth Amendment right not to bear witness against ourselves, insisting upon our right to confront evidence against us and summon our accusers for cross-examination in IRS proceedings, educating millions of people about the income tax issue in as many ways as possible, including use of the internet and newspaper ads, and enlisting the support and voices of people prominent in government who share views about the illegal operations of the income tax system and the IRS, and who can help do something about it from within the government. Yet another prong will be the creation of a blue ribbon panel of legal, constitutional, and historical experts to study and report on all aspects of the allegations that have been made. We'll talk more about that later, but let me say now, if the executive and legislative branches, the political branches of our government, will not pull together, will not identify constitutional scholars, attorneys, and historians to review this evidence and comment on it, then we will. At this time, I want to ask whether there is anyone here representing the executive or the congressional branch of the government who has come to debate one or more of the propositions in question. Is there anyone here?
Good luck.
We have 3 empty chairs. If anyone does arrive, we have 3 empty chairs for representatives from the executive branch and the House and the Senate. As many of you know, beginning in May of last year, we have very respectfully requested the leaders of these branches to identify their most knowledgeable people and have them come and debate the conclusions of these researchers. And so we have published before this conference, one final open invitation, and we have seats for anyone that might come representing the 2 political branches. Well, it's clear by now that the government can't be shamed or provoked into answering the challenges, that the government has no defense against the charges, and that we must interpret their evasion as being an admission that the allegations are true. Apparently, not even our 2-page ads in the Washington Times could prod them to respond. And wait till you see our full-page ad in USA Today, coming out a week from tomorrow. Not be out tomorrow, but a week from tomorrow. Now, let's hear from our speakers. First up, Galen Whitey Harrell. On May 26, 2000, a jury in Illinois acquitted Mr. Harrell on all 4 counts of failure to file an income tax return after the jury sent 2 notes to the judge asking the judge to show the jury the federal and state laws requiring people to file an income tax return. And when the judge refused to provide any such information, the jury acquitted Harrell because of a demonstrable lack of evidence that there is any law that compels most citizens to file and pay the federal income tax. It's a pleasure to introduce Galen Whitey Harrell.
I want to thank Bob Schultz and We the People Education for inviting me and for putting forth this great effort to provide a podium for myself and others to bring a message and spread the message to this nation. My message is always keep asking, where is the law? Show me the law. It was very beneficial in my case. There was an event that recently took place in central Illinois, just outside the capital city of Illinois, Springfield, that really shook my socks. There was a trial that took place in Lincoln, Illinois, starting on May the 24th, 2000, that I feel resulted in a great victory for the working classes. I kind of want to start out by relating to you this trial, or my trial, had similarities with a trial that took place in California a few years back. And that case, in part, hinged on an article of clothing as evidence. And I want to use that article today to sort of help demonstrate my message. So I just ask for you a moment to let your imagination sort of flow, and we'll call this article of clothing, we'll call it the law. Okay? Okay. And I want to say that if the law don't fit, you must acquit. Okay? Okay? And this is what's happened in Lincoln, May the 26th of 2000. This question arose: where is the law that fit this felony crime of failure to file Illinois' return? In Illinois, it's a felony, class 4 felonies. And in this quest of asking to see that law, the law never surfaced. And the results was an acquittal by 12 jurors. They voted 48 times. Not guilty, not guilty, not guilty. And you're going to hear that story today from a juror's perspective, okay? I think that you will find that more interesting than me standing up there telling about anything with my case, with my experience. And we are on a short, limited budget of time based upon the amount of speakers. So, you know, I'm going to yield much of my time to Marcy Brooks. She can step forward and present what the debate was in that jury room, what they saw, what she saw and others saw from the jury's perspective. And thus, I'm going to yield to give her more time to provide something that I feel and believe that you'll find more interesting, okay? And I thank you.
Whitey doesn't really get off that easy. There's several questions he needs to answer, and he's going to answer them, and he just hates being up here. It's a delight for me to be here. First of all, I want to say and clarify that I am not the juror, okay? There were 12 of us, and 12 fine citizens who were very concerned about doing what was right. When we first entered the courtroom, it seemed very easy, you know, well, okay, did he file or didn't he file? That's not too difficult to decide, you know. But it didn't take us long to realize that it wasn't going to be so simple. First of all, Agent Craner, who was the man who had been investigating Mr. Harrell for 3 years, came to the witness stand with no paperwork, no files, empty-handed. They asked him questions, and I assume that he's a fairly intelligent man, having to have had the job that he's had all these years, and he just couldn't seem to remember anything. And, well, y'all, I think Mr. Harrell asked me some questions, but I don't think I wrote them down. And, well, I'm not real sure about that. Well, yeah, that could be. And we're going, how long have you been investigating this case, you know? And he spoke real softly and just kind of mumbled, and you know, I guess I assumed that an investigator would be more well-spoken, and so that immediately aroused in me some suspicion. Something isn't right here. And he said, I don't remember writing down any questions for Mr. Harrell. Well, then they brought on a video of the interview with Mr. Harrell. Keep that in mind, okay? And there he is, writing away. And every question that Mr. Harrell would ask, he would write away, and then he would say, I'll get that answer for you. I'll get that answer for you. And they said, did you ever get back to Mr. Harrell? Well, no, sir. You know, and again, we're going, why? What? This is so strange. It shouldn't be this difficult, right? It is the law, right? So it shouldn't be this difficult. Well, then Mr. Harrell was able to testify. And at one point, when all this is going on, and they had, I don't know how many witnesses, to prove that Mr. Harrell lived in Illinois and that he was married. And we're going, that's real interesting. You know, you didn't have to really convince us this hard. But after a while, I finally raised my hand, because I had been told that the judge would receive questions, and I raised my hand, and he's going, what? Whoa! He says, I don't have time. And then he backed off, because I just looked at him. I said, pardon? You know, and he said, I'm sorry, what was your question? And I said, I think I just need to be clarified. What is Mr. Harrell being tried for? And he read again, you know, the charge of willfully not filing income tax in Illinois. I said, okay, thank you. You know. So Mr. Harrell got up and had a very calm and brilliant testimony. We were all impressed. And finally, he looked at the prosecuting attorney and he said, I'll ask you the same thing I've been asking all along. I don't mind paying my taxes if it is the law. Just show me the law. Yeah. And so we sat there. We're going, all right, this is it, you know. They didn't even address the question. Not only did they say, you know there's a law, or they went on. And we're going, what? This was your moment, guys, you know, the spotlight was on you. And they didn't even address his question. So again, red lights are going off. The judge finally told us, he said, because the defense kept talking about, you know, where is this law? And the judge finally looked at us and he said, I will instruct the jury according to the law. And we went, oh, okay, he's going to give it to us, you know, maybe in a nice little format, whatever. So, needless to say, as soon as we got into deliberation, what did we look for? The law. And we're going through papers and going through papers, and we're going, okay, so where is the law? And finally, there was this one piece of paper, and it said, if you are filing jointly and if you are married and filing jointly and under the age of 65, you are required to pay Illinois taxes if you make this much money. And somebody said, there it is, there's the law. And I said, I think that was the tax code, wasn't it? Isn't that what they said was the tax code? Well, isn't that the law? And I said, no, didn't they talk about that? Well, yeah, we all came to agreement. No, that wasn't the law, that was the tax code. But they said, but if the judge said it, it must be the law. And we had one dear gentleman that was from Romania. And he's an American citizen now, but he said, you know, in my old country, we couldn't challenge the law. But in this country, we can. And so I said, okay, let's look at it this way. If it's the law, they shouldn't have any trouble telling us what the number is, right? And they said, you're right. You know, if it's the law, they can give us the number of the law. So that's when we wrote our first request. I wrote out the request, and I said, would you please give us the number of the law that has this wording? And then I took the wording right off of the paper that he had given us. We waited a few minutes, and by the way, the bailiff was fairly new, and he was like going bonkers. He's going, you want to give a request to the judge? Well, I don't know. I've never seen that before, And so, anyway, in a little bit, we got back our answer. And we looked at it, and it said, you have been given everything you need. Well, needless to say, we weren't pleased. We're going, if it's that easy, why didn't he just write it down? Now remember that we'd gone through this whole trial from Wednesday afternoon till Friday morning. The Attorney General's office had all that time just to tell us what the law is. And we heard nothing. We asked the judge, just tell us the number. And one of the jurors said, well, you know how the law is. It's real complicated. Maybe he thought if he gave us a copy of it, we couldn't understand it. And I said, we didn't ask for a copy of the law. All we asked for was the number. And we were refused. So we went on to the issue of voluntary compliance. And this is when things got heavy, because we're starting to look at each other and people are going, you mean we don't have to pay taxes? And so then we got into, well, is it a moral issue? And, government has to have money to do what it's doing and blah, blah, blah. And I know you'll have answers for that, but realize we were talking as dummies, okay? And so, we're going, boy, this could get out, It's a pretty serious case. All of a sudden, this little case that we had all just shown up for to do our civic duty had become an awesome case with tremendous possibilities, And so that's when the heated element kind of came in, because people started getting emotional about taxes. And finally, I said, now wait a minute. This is not a moral judgment that we're making. We're judging Mr. Harrell on the law. Let's get back to what we're talking about. We're judging him according to the law. Have you seen the law yet? No. So that's when we sent our second request. And we went to, and I wrote out to the judge, I said, would you please, because when we were talking about voluntary compliance, let me back up a little bit. When we were talking about voluntary compliance, finally, one of us, I don't know who exactly said, well, that was in that evidence that the defense gave. That Mr. Harrell refused to bring, the defense did bring their own copy, and it was accepted as evidence. Right, so we start flipping through papers. There's no evidence. Where did it go? And we're looking all over the table. Well, aren't we supposed to get all the evidence? And so we sent a second request. Please give us the papers that were submitted as exhibit number whatever for the defense. And we waited, and we got a note back, and it said, you have requested, blah, blah, blah. You're being denied. At that point, the other three jurors swung. They said, something is really wrong here. And so some of them said, well, I just don't know. He's going to be getting away with it. And I said, wait a minute, if it's not the law, he's not getting away with anything but standing for his rights. And they said, well, you're right, But, we're so deeply ingrained in this, and please be patient when you talk with other people. This is something that we've been taught all of our lives as a citizen, it's part of our being. And so we had to crash through that and go, but what are we really talking about? We're talking about the law. And I read the instruction from the judge, which I don't have his exact wording, but basically it was, if he's not guilty, then he's not guilty. And that's when we all voted and we signed the papers. Finally, I will never forget, for one thing, the white face of the judge. But the other that I will never forget are the mixed feelings of humility and pride. As the clerk read, we, the jury, find the defendant, Galen Harrell, not guilty. And our eyes were all on Mr. Harrell because we had grown to appreciate this man's dedication. I mean, this obviously wasn't just somebody that didn't want to pay their taxes. He believed in this and was willing to put out everything for his belief. So with each count, there were 4 counts, every time they said, not guilty, his emotional stance, the first time he just convulsed, you know, and it was just, you could tell that he had been under such a strain, and that when they said not guilty, he just, you know, and then with each one after that, people in the courtroom started crying. And I sat there and I thought, maybe the system doesn't work all the time, but this time, for that man, it worked. And the conclusion is, no law, not guilty. Thank you.
Are you up to answering a couple questions? Okay. Whitey, do you work for someone else? If so, have taxes been withheld from your earnings? And if so, how can you get that money refunded?
Yeah,
You want to speak at the microphone?
Yeah, I work for the U.S. Postal Service. I'm a rural mail carrier. And there was a lady brought in from the post office to testify as a witness for the state. She was there to testify to the W-2 earnings. And she identified herself as working for the United States, for the U.S. Postal Service. And so when it came defendant's opportunity to question her, the question was, does U.S. mean federal? And the answer was no. It's a private corporation. It's a private, okay? And just want to point out to you that during the course of the trial, the state was using the U.S. Master's Tax Guide as the law to show the liability supposedly on the federal level, which in turn causes the necessity, their claimed necessity of filing an Illinois return. The question came up about whether U.S., a master tax guide, is the law, whether Congress authorized this. Does Congress put this out? And the answer is no. This is not law. It is published, created, and for a term to get the message across by Piggly and Wiggly, okay? It's just private. And this became a heated debate about whether or not dealing with the question of the law.
Thank you, Eddie. And Marcella, did they try to eliminate anyone from being on the jury on the basis of their views about taxes? And another question, if you can handle two of them, if you can remember the second one. To what extent was this really, in effect, a federal tax case? Is Illinois tax law similar, or is it predicated on federal law?
Well, in answer to the first one, I would have to say yes, someone was kicked off the panel because of their views of taxation, but it was actually in Whitey's favor. Some dear little lady was in the back row, and they said, "How do you feel about paying taxes?" And she goes, "Well, everybody has to pay their taxes, don't they? I mean, you just get your little piece of paper in the mail and you fill it out and you pay your taxes." And they went, "You're excused." At this point, I would have to say I believe in providence, because when they asked me what my views on taxation were, I said, well, I've always believed that I should pay my taxes, but frankly, I've always really thought that the Boston Tea Party was really neat. And I said I've been a patriot at heart all my life, and I have known of people who refuse to pay their taxes as a final recourse in making civil disobedience, their only way of making a statement about what they believed in. And I thought that was pretty great. And I thought, I'm out, They let me stay. And that's, like I said, I have to say it's providence. God had to have just said, just don't hear her, he shut their ears or something, I don't know. But anyway, so that's my answer to that.
Okay, thank you, Martha.
Oh, my other question, federal.
Right, I forgot.
See, it ended up being a federal case because we got the indication that the first stipulation for paying Illinois taxes is paying federal taxes. And so we said, no, wait a minute, if you don't have to pay federal taxes, then obviously you don't have to pay Illinois taxes. So I guess in a way it did end up being a federal case.
Right. Okay, Dave Bossett, the Florida employer, and Dick Simcanen, the Texas employer, and Nick Jessen, the California employer, have each notified the IRS that they will no longer be withholding the income tax from their workers and that they will no longer be filing W-2s and 1099s. Each provided the IRS with extensive legal arguments in support of their decisions. Dave Bossett was first to do so. The IRS returned the money to him he withheld in 1996 with interest. Let's give a warm round of applause again for Dave Bossett.
For all of you who were present in November, I don't have any slides. I'm not going to talk for an hour, I promise. Maybe 55 minutes, but I look at Bob's schedule and I think I run out of time in 6 minutes. You're all lucky. First of all, Bob, thanks for inviting me back. Those of you who are here in November know that I spent a fair amount of time, approximately 2,000 hours, studying the law, looking at what the laws, the regulations, and everything said. I want to give you all one admonition if you're going to embark on this process at any stage. Study what you're doing. Know in your own heart and your mind what you're doing. Don't believe me. Don't believe anybody else. Prove it to yourself. Go to the law library. Look at the extensive documentation that the government puts out on their websites. That was probably one of the cleanest pieces of information that I came up with to prove the process that I was embarking on. Remember, I trained as an accountant. I trained as a CPA back in the 60s. I had a thriving tax practice after the CPA field. I processed thousands, if not millions, of paychecks for people, dutifully deducting taxes from them. Had a good time destroying other people's lives, I found out. And maybe that's why I stood up and became, if you will, a target, as some people have said, simply because I'd done it for so long that it was time to make amends. But again, don't take what I say as the truth. Go find the truth for yourself. I'll try to point you where I found it, but go verify it. You may come to a completely different conclusion. But Dick and others came to the same conclusion after they studied it. I'm not going to go into a large amount of detail of what went on and what I did. I'll give you, if you got your pencils handy, I'll give you a website and an email address. If you want to get into detailed questions, be more than happy to entertain them. Keep in mind that my inbox when I left yesterday was 768 messages that I haven't got to. So don't be alarmed if you don't get an answer in 2 minutes, unless I happen to be sitting there looking at it when it comes in and your answer is easy. I've surprised a number of people at 3 o'clock in the morning when they get a two-minute response from me to their email, so it does happen. The email address is Dave B. Just Dave B. at Bossett, BOSSET.com. That's one T on that, Bossett. But if you got questions, feel free to address them to me. I will try to answer legitimately anything that I can. Most of my paperwork that you can find has been published on the web. It's located at www.nite.org. I haven't published it on my own website yet. Someday I'll get to that, but please forgive me. I'm just so busy. I really haven't done it yet, and it's already published and available to you. In a nutshell, where I stood on the law and on the regulations. And you notice I'm not going to talk about a chasm that I've got to jump across. I have a kind of a simile that I give people about what I have seen in the network or in the net for different theories of law about taxation. You're driving down the road at 60 miles an hour. Everything is beautiful. You see a big hole up in front that you can't explain. Rather than stepping on the brake, a lot of people push on the gas knowing that they can just jump across this unknown. You can't deal with the IRS that way. They will detect it immediately. I think Joe can spread some light on this when he gets up to talk. But if they see that you don't know what you're talking about, you're dead meat. It's that simple. I've seen it time and time again. I've sat in on court cases. I've studied court cases. And literally, if the person had any kind of lack of knowledge on where they were standing, they got chewed up and spit out. Don't become part of that. Know what you're talking about, and then act after you have determined what is true and what is correct. In a nutshell, and I'm not going to go through all of the arguments because all that documentation is available. By the way, if anybody wants a copy of the slides that were presented back in November, just email me and I'll send you a copy of the full outline so you can go through and test piece by piece what's out there. But I look at the core of the issue as taxable income. If you go to Section 63 of the Internal Revenue Code, Title 26, you will find that taxable income is gross income minus allowable expenses. And these are not exact quotes, these are nutshell words. Go read the law. Go see what it says. To find gross income, you do a search and you'll find Section 61 of the code that talks about gross income. And it says from whatever source, just like the 16th Amendment says. And I'm not going to argue Bill's argument for him. He can do that well by himself. But at that point, it also points at items. Now, trained as a tax preparer, I don't know how many times I've turned around to my bookshelf, brought forth the tax code book, probably it was CCH or Prentice Hall at that point in time. I opened it up to Section 61, turned it around to my client, pointed at that section and said, which one of these items are you asking about? End of question. Nobody challenged me at that point in time because there it was in the law. I believed it just like every other tax preparer did because it's very, very clear. Until you realize that the word source, the key word up in the start of Section 61, is not what you think it is. You and I know that whatever source is whatever source. I mean, any place you get money, it counts. The Secretary of the Treasury in CFR 1.861-8, a very lengthy document. If you pull that document, for example, when I pulled it off of the government website, it printed for 33 pages, very tightly spaced, very much, as a tax professional, I can tell you, gobbledygook. I can't imagine having read that and got past the first page before I simply flipped to the next section 30 years ago. I can't honestly say I read it. But when I read it this time, I got down to page 13 in this document in a miscellaneous section, and lo and behold, they define the word source as it applies. The words of the Secretary of the Treasury, published as required, everything that applies to us. And in that words, it says that if, in effect, and I'm paraphrasing now, if you are an American citizen and you work for an American company and you live in the United States, your remuneration is not taxable. And it's that simple. Now, there's a lot of words there to get to this point, but it comes out that simple. If you happen to work in Puerto Rico, it's taxable. If you happen to be a resident of Guam and working in the United States, it's taxable. This goes on through this whole process. I think there's 13 or 14 conditions that you must hit to become taxable. And if you don't hit those conditions, the sources don't apply. Now, I'm not revealing anything new. There's people in this room who studied this and discovered it 10 to 15 years ago. I mean, I haven't went back through everybody that has been involved in it, but I'm not talking about anything new. I discovered it on the net. I was reading an article that talked about how an employee could do this, how the employee could refute the employer. And I sat upright in bed one night, my gosh, if the employee can refute the employer, why can't the employer simply do it right in the first place? Now we come to the part where the rubber hits the road. 99.99 something % of the employers are scared to death to do it. So let me talk for the rest of the time, if Bob will give me the time, about what you can do, because this is the question I get most. I work for XYZ company and they won't listen to me. What do I do next? I take and recommend a very non-confrontational method of handling this issue. Most people that I talk to, and I talk to a lot of them, don't want to lose their job over the issue. They want to feed their kids. So let's talk about how you go through the process, and if nothing else can make it very difficult for the employer to keep his stance. Now remember the rules of evidence, and an attorney can tell you about this a lot better than I can. But if you document your steps, and you document them properly, all of a sudden there becomes a confrontation at some point in time. And I'll get to that confrontation in just a minute. But what I expect you to do in a non-confrontational way is to document to the employer. In other words, send him the appropriate documentations, a letter or whatever, explaining the law to him. He will turn it over to his legal team, possibly, and they will say that it doesn't matter. The law says we got to withhold the money. Fine. Let them withhold the money. You have done your part at that step. When you get your first check and you've got the money withheld after you've sent this letter, send a copy of the letter with a reminder letter that says, I told you that you shouldn't do this, and you're still doing it. Okay? Again, non-confrontational, just simply documenting the issue. Eventually, the end of the year will happen. They will continue withholding because you'll get ignored at that point in time by most employers. Then, when you get the W-2, go through what I refer to as the 4852 process of refuting the W-2 to the employer in writing, asking him to correct the errors of his way and return your money. Chances are he won't do it. At that point in time, now you go through the 4852 with the government. In other words, you're now, and I recommend filing the income tax in a very special way. But what you're going to do with that 4852 process is, in effect, refute the testimony. Because remember, the W-2 is testimony from the employer to the IRS under penalty of perjury that these are true and correct. IRS takes them and they rely upon that testimony. And that's the only testimony against you on a W-2 case. 1099 is the same situation. It's the only testimony against you. The IRS, when they come to a court situation, they will be bringing in their experts to say that, yes, we received the W-2. They won't bring the employer in, but you can if it ever gets to that point in time, because it's an adversary situation if they're at that level. Now, when you're claiming that money back, if it's done properly, you've now set up to go into court to get that money back. Now, let me ask you a question, and each one of you can think about this and answer it in your own mind and your own heart. Would you rather be the plaintiff in a money recovery suit in federal court or a defendant in a criminal trial?
Plaintiff.
It's that simple, okay? I don't recommend that anybody get to that point. Whitey was there. I don't think he'd recommend that anybody take that route either. If you
Plaintiff.
always position yourself to be the plaintiff. I doubt seriously, and I know of no reason why I would expect that IRS would ever let you put the quote-unquote testifier, the employer, on the stand. Now guess what happens when you tell the employer that you would wish them to stop withholding? IRS has given me the money back. They've agreed that you were wrong. Now the next time, are you a co-conspirator if you continue doing it? But all this time, I haven't done anything to cause the employer to be mad at me. I haven't confronted him and made an either-or out of it. Let the IRS and let the courts take him through this process. Now, there's probably flaws in what I'm talking about. Study it very carefully, learn exactly what you need to do, and then once you're convinced, if you decide to act, then you're acting from knowledge, not because Dave told you to. And please don't let anybody else tell you to in the process. You know, it's something that you've got to know what you're doing. Otherwise, if you don't know what you're doing, Larry is the next guy that you see down the line here. He'll help you with your problem at that point. But if there's any questions, just address them to the website. I'll get off of the high horse here and let Bob have the podium back, and just go forward, but go forward in knowledge. Don't just simply drive down the road and be really sure that if you press on the gas, you can jump over that hole. Won't happen. You'll fall in. Don't.
Dave, is everyone free to take your charts and other information that has been published on NITE? Are they free to take that information and publish it and put it on their websites as well?
Everything, Bob.
I have to speak into the mic.
Everything that I publish in the open is for anybody to use. Okay, again, make sure it's yours in the form of knowledge before you rely upon it. Now, one thing, and Bob, I'm going to do something out of school here for just a second. In my company, I have the need for one attorney for our corporate use. I'm going to hire 3. And people think I'm crazy, but I'm going to create a defense for Dave Bossett in this issue. If IRS ever wants to come and tackle, I'm going to have 4 attorneys that are prepared, ready to fight the battle. Now, if we don't have to fight the battle, at that point in time, we probably will make that attorney group available to the world, quote unquote. And I'm planning on funding the operation to 4 researchers, 4 attorneys, 2 clerical people, 2 pilots and 2 aircraft so they can go any place in the country. And before you get excited, that does not mean that if you call, we'll be there. Okay? I happen to know that there are more cases than we could possibly be in front of across the country. So we'll be picking and choosing until we get very good at what we're doing. But literally, I see that the government has a problem. Look at the empty chairs. They have no apparent defense for what we're talking about. I cannot find anything. There's been a number of people who have said, Dave, you're in trouble. I actually got this on our local CBS news station and got very, very good coverage from the local station. To balance the news article on the Friday night expose time, they brought on a CPA who said, he's in trouble. Okay, he'll get audited. I mean, I've never heard of somebody getting audited by the IRS on 941s and W-2s, quite frankly. I've never experienced it simply because there was nobody standing up and doing that. I don't think they've got a procedure for it. If they do, we'll be ready. We're going to tackle it. I would have normally given the money that we're talking about to fund this legal team. I would have normally given that money to charity. So it's not Dave being a wonderful guy. It's just simply the charities are going to have to spread just a little bit thinner. But I think the charity belongs right to the taxpayer. You know, that's where it ought to start, and we ought to all be doing it correctly, and because of that, we're going to act and we're going to put it on. So if you've got a problem that it looks like it needs the attorneys, we'll have an email address on the thing that you can explain the problem to them when we get it set up. Feel free to, how do you say, ask the experts. Don't consider this my guarantee that they will get in the plane and be there the next day. But if it's the right case, the right situation, we're going to tackle it. We're going to bring in people. I haven't formally asked Larry to do this yet, but he will be brought in, if he's willing, to do seminars for the attorneys so that we can bring the people up to speed. One of the problems you get into in this situation is how do you find an attorney that'll follow the law? As crazy as that statement sounds, it's very difficult to find an attorney that will actually read the law and go forward.
So I guess, Dave, it's fair to refer to this as either the Dave Bossett approach or the 861 sources argument. Either one?
Let's call it 861, Bob.
861 sources argument. At this point, I'm going to deviate from the schedule just a little bit. As we were taking care of registrations this morning, I was approached by 2 young men who identified themselves as not affiliated with anyone, who have done, have taken the time to put together the background and this argument from their professional points of view. And I'd like to ask one of you men to take that microphone and very briefly explain that document that you handed me, that you have copies of, that you've made available on the table outside. I scanned it. It looked pretty well done. I'd like you to briefly describe what it is, who you are, and what that document is, please.
It was an unexpected pleasure. My name is Gordon Smith. I came down from Philadelphia. I personally did not do the research. The friend who did the research, his name is Larkin Rose. I know he's spoken to some of you on the panel, and he has this document is also available on night.org. He's done about 1,000 hours of his own research, come down here to the Congressional Law Library, and he's presented it several times, and again, no one has ever been able to come up with any proof against what he said. So I find this document very heavy-going, but very thorough. So I encourage you to take a copy of it out there on the table.
And the focus is the 861 sources argument.
It's an exhaustive exploration of the 861 source argument.
So take heed. Dave Bossett has warned us to be knowledgeable about the subject. You have Dave's work available now, and you have this work as well. And there are copies. I don't know that you brought 100+ copies, but there are. What is the website?
The website is taxableincome.org.
And this is published on the website?
Yeah. This document is available on taxgate.com. Go down to Taxable Income by Larkin Rose. His own website is taxableincome.net.
.net.
Thank you
Okay,
very much.
you're welcome.
Bob, I've met with Larkin and read the article, and I support it, Bob.
Did you speak that into the microphone? Thanks.
I've met with Larkin, I personally know him, I've read the article, and I would support it fully. Again, the caution, make it yours, not Larkin's.
Okay, the next employer who has, following Dave, who has notified the Internal Revenue Service that he is the founder and CEO of his company, will no longer be withholding taxes nor filing W-2s and 1099s. Dick Simcanen from Texas, CEO of Arrow Custom Plastics. Let's welcome Dick Simcanen.
Thank you, Bob. Good morning. This is my first visit to the United States. So the question is, who am I? Why did I do it? And what did I do? My name is Dick Simcanen, founder and CEO of Arrow Custom Plastics. Arrow Custom Plastics is located in Texas, and we are tool builders and injection molders. So we're just the run-of-the-mill, normal business across the United States. I think there's probably 5 to 10 million businesses. On January 1st, 2000, I stopped all withholding from the company's 45 employees. And of course, why did I do it? Well, back in 93 or 94, I got caught up in the tax movement, and with a lot of patriot mythology and hype, I decided personally to stop filing an income tax return. All my studies continued, and my actions became based more and more on law as time went by and less on mythology. But as I listened and learned more about the individual struggles that people were having, it became apparent that the employer was the kingpin in all these problems. I'm an employer. And the problem is the gross misapplication of the tax laws. The IRS tells the employer, and Mr. Employer, you have to take and have your potential employees fill out a W-4 form. Well, a W-4 form is an agreement between an employer and an employee. Then what the employer does is send a copy of that W-4 to the IRS, and the IRS enforces the contract between the employer and employee. Duh. Next is the Social Security number. IRS, through its publications and whatnot, says, Mr. Employer, you need to get a Social Security number from your employees or potential employees. Well, now wait a minute. Isn't the Social Security number, or at least the having a Social Security number, voluntary? Don't we apply for a Social Security number? It's not mandatory. We're not given it. It's not given to us mandatorily at birth or whenever we start a job. We apply for it. So it's voluntary. And then there's this thing called a I-9. Well, I don't think it's applicable. I think the I-9 refers to agricultural and vegetables and fruits and that kind of thing. In the middle of 1999, I was struggling with these concepts. Gross income, source of income, items of income, and so on. Well, I finally came to the conclusion to stop withholding in September of '99. That's when I made the decision. I prayed about it a lot. I talked to people like Dave Bossett on the phone. I've talked to several CPAs, attorneys. I did research on the internet. I read law books. And I made that decision. But I knew I had to go about this with some sort of plan. I couldn't just spring it on the employees because, like Marcella says, this is an ingrained thing. You know, what are you doing to us? Or you're going to put us all in jail here. Or you're going to have the locks put on your doors and we're going to be out of work. So I used October, November, and December to educate the employees. I took all of the stuff that I had learned. I've made copies of the laws from the law books. The research off the internet, I made copies of that, provided it for the employees. I put this information in the break room. And for 3 months, they were indoctrinated with the law. On December 18th, 1999, I brought a gentleman in from California by the name of Dave Bossett. Dave Champion. Dave Champion is a paralegal. Excellent speaker, and we arranged a meeting with the employees. During that meeting, Dave could articulate very well the position that Aero Custom Plastics has taken, which kind of put the employees at ease. And he was also available to answer a lot of their questions. Between Dave and myself, we told the employees what their options were, which I won't go into a lot of detail here, but you do have options, as does the employer. So on January 4th, I believe, which was the first work day of the year, we did stop withholding from 45 employees. Now the result of that, when you have that many people, of course not everybody is going to agree or disagree about what you're doing. We actually had a couple of people quit because they were scared. We had a couple of people, through the education that we gave them, decide that right off the bat they were not going to file an income tax. And of course, we had those that are just going to have that wait-and-see attitude. Let me go through a little bit of education that I did. I don't know if most of you are familiar with Richard Standering's courses. He has a level 1, level 2, and level 3. Very interesting. I attended all of those over a several-month period. I used Ben Houck up in Ohio for IMF and BMF decoding, which really is my argument with the IRS. On January of 1999, which was a year ago, or a year and a half ago, I sent for my IMF, which is an individual master file. I sent it to Ben for decoding. He sent it back with all of the decoding on it. Interesting things were on there. I was contributing to the Railroad Retirement Fund. I was paying political action taxes, inheritance taxes, gift taxes, and a few other odds and ends. It didn't make sense to me. So I put together about a 20-page letter asking the IRS about these things on my individual master file. Of course, I have yet to receive an answer. So I did the same thing with the business, which is called a BMF, business master file. I wrote the IRS a letter with the help of Ben Houck in all his translations, and I didn't get an answer. So I decided to write my congressman a letter, Mr. Joe Barton. He's in the 6th District of Texas. And let me read this letter that I wrote to him. As a concerned business person and owner of a small company in the great state of Texas, I have been somewhat disillusioned by the activity of the IRS. From time to time, I have asked the Internal Revenue Service specific questions about the company's liability and certain taxes and the company's authority to provide certain functions on behalf of the IRS. For the most part, I have received no answers or answers that were way off point. In my attempt to further understand the requirements and methodology of the IRS, I had requested through FOIA the BMF specific for my company. After decoding the BMF, I was surprised to find what appears to be a massive amount of computer fraud. Please review the enclosed copies of BMFs and the supporting documents that I have sent to the IRS. Since I do not expect to hear from the IRS, I am asking you to do whatever you can to help me obtain some answers. Thank you for your time and investigation in this most important matter. Well, I did receive a response from Mr. Barton. That response was on January 25th, 2000. Dear Mr. Simcannon, thank you for your letter in which you asked for my assistance concerning the recent request you made to the Internal Revenue Service. I appreciate you contacting me. On your behalf, I have forwarded your letter and documentation to the IRS. As soon as I receive a response from the agency, I will be back in touch with you. In the meantime, if you have any questions, please contact my case director, Christy Townsend, with the telephone number. That was nice. On April 17th of 2000, I received a second letter from Mr. Barton. I am writing to let you know that I have not yet received a reply from the IRS. Regarding the inquiry I made on your behalf, I have requested a status report from the agency. Please be assured that I will be getting back to you as soon as I receive the response. In the meantime, do not hesitate to contact my office if you have any questions. I appreciate the opportunity to assist you in this matter. Well, that was good. On May 9th, 2000, I received a third letter from Mr. Barton. Dear Mr. Simcannon, this is to advise you that I received word from the IRS that my inquiry on your behalf was added to your file several weeks ago. The agency will notify me of any decisions made in your case. I know that you are anxious to have this matter resolved as soon as possible. You may be certain that I will pass along to you any additional information as soon as I receive it. In the meantime, if you have any questions, Well, in a conversation with Joe Bannister last night, I informed him that of this letter, and he said, that's pretty good, because at least you've got proof now that your rebuttal is in your file, confirmed by the congressman. So I'm happy about that. So what is this thing we call income tax? Is it a tax on income? Well, not really. It is merely a tax classification, such as a so-called normal tax or inheritance tax, gift tax, all of which is in Title 26, Chapter 1, Social Security tax in Chapter 20, in the Social Security tax in Chapter 21, the government personnel employee tax in Chapter 24, gambling tax, Subtitle D. These are all species of income. So the tax is not on the income. The income is merely the yardstick that measures an excisable, taxable activity. Alcohol, tobacco, and firearms taxes in Subtitle E is another example. The income tax is not technically a direct tax. Both the lower courts and the Supreme Court have made decisions that on both, about 50-50, that the income tax is a direct tax and it's an indirect tax. Well, if the government can't decide on what kind of a tax it is under the Constitution, isn't there such a thing called void for vagueness? Wages, salaries, compensation, and the like are concerned. They are not the object of the tax. They are the measure. The objects are the activities, privileges, and the benefits. The family of Social Security taxes in Chapter 21 may be the only exception. These taxes are social welfare taxes. They are direct taxes where they are imposed for the supposed greater good of the entire population. There is no Social Security fund. You all the time hear about the politicians talking about Social Security trust fund. It doesn't exist. The money collected for Social Security goes directly into a general fund. Then Congress appropriates benefits to the classes that receive whatever benefits are designated for that class. So Social Security is one of the items in the budget that Congress discusses every year. And they appropriate funds to be paid out of the general fund for Social Security benefits. From the beginning, our government has been prevented from taxing one for the benefit of the other. So if the government taxes you, takes your money, and gives it to me, that's redistribution of wealth. That's socialism. Taxes are collected by government of the United States, whether direct or indirect, must be used for support of the government as it carries out powers enumerated by the Constitution. In 1935, when Congress first attempted to impose Social Security welfare taxes, the Supreme Court overturned the legislation. When the Social Security Act of 1935 was subsequently enacted, it applied only to Washington, D.C., territories, and insular possessions of the United States, not the states of the Union. So all you people that live here in D.C., you're privileged. You have to pay Social Security by law, but you also get to collect the benefits. The people that live in the several states, it's voluntary for them. They can choose to participate or they don't have to. And they don't have to do it through their employer. And the employer is not obligated to withhold those taxes. This is the case today. The Social Security Administration has lawful authority and can legitimately extend the social welfare system only in the District of Columbia and insular possessions, identified in applicable definitions of state, United States, and citizen. Now, these definitions can be found in 26 CFR, section 31.3121, paragraph E-1, which is why in the beginning of my talk I said this is the first time I've been to the United States. How am I doing? Okay, let me get to an area that I did want to. There are many persons in the United States who are, by law, required to pay a graduated income tax, but there are also many more who are not made liable, and that's probably most of you. As a Christian, I'm often confronted with Romans 13:7. Render unto Caesar what is Caesar's, and unto God what is God's. Well, since when does Caesar on a par with God? Everything on, under, or above this earth ultimately belongs to God. Therefore, to say that Caesar has a certain realm of obedience to God and another realm of obedience to Caesar is totally false. Our Caesar today recognizes the higher power of God when it inscribes on its money, "In God we trust." As our forefathers said, only one God, or only one king, Jesus. So for titles of nobility, you can check out the 13th Amendment. If you're not convinced and still say that our income tax laws are being administered with justice, then pay careful attention to the balance of this conference. There is overwhelming evidence that clearly shows that the income tax laws are a masterpiece of deception and are being grossly misapplied. I am a free citizen of Texas under the Texas Constitution and the Constitution of the several states. I took a stand in 1995 against the unjust authorities. I cannot and will not obey our authorities when it means to surrender the lordship of Jesus Christ. I am ready to defend myself in court, and I am ready to go to jail, if necessary, for my beliefs and convictions. After all, I would be in pretty good company, since much of the New Testament was penned from prison. For those who are concerned with your reputations, your positions, your friends, your salaries, I quote the appropriate words of Samuel Adams. If you love wealth better than liberty, the tranquility of servitude better than the animating contest of freedom, go home from us in peace. We ask not your counsel or your arms. Crouch down and lick the hands of those who feed you. May your chains set lightly upon you. May posterity forget that you are our countrymen. That is good advice for all us Christians, especially for preachers. We are obligated to obey the Bible regardless of the consequences. It is time to stop fearing what man can do and realize that God's judgment can be far more intense than anything man can do. It is time to tell authorities that we will not obey them when obedience to them results in disobedience to biblical principles. Amen. Thank you.
Thank you, Dick, and that is great testimony. If you haven't considered doing so, you should write a book. Okay, we're going to, there's a plea here that I've received. We're going to take a, what time is it? I don't have a watch.
10:32.
10:32. At 10:37, which means you have to hustle, we're going to be back here. Take a brief break. Lots of coffee and water is being consumed. We'll be back in 5 minutes, please. Okay. We're waiting one more minute for people to return. I assume everybody knows by now they should have been handed copies of the Washington Times when they registered. For last week's, the last week Washington Times, the National Weekly Edition, and this week's, which have the centerfold advertising, the ad that we published. Those of you who do not have those copies, there should be copies available outside. Okay, we'll get underway. Thus far, we've heard from a juror and a defendant in that case, acquitted because of a demonstrable lack of evidence of any statute that required that defendant to file and pay his income taxes. And we've also heard now from employers who, for the same reason, are no longer withholding and no longer notifying the Internal Revenue Service through the W-2s and 1099s that workers for them are liable for those taxes. Now let's turn our attention to some of the researchers, some of the people whose work is being relied upon now by a growing number of jurors and employers. Bill Benson, in 1985, published the results of his exhaustive research on what actually happened in each state, 48 at that time, between 1909 and 1913 regarding the proposed income tax amendment to the U.S. Constitution. Bill's work proved that in 1913, the lame duck, Secretary of State, 1 month before he was scheduled to leave office, committed fraud when he declared that the income tax amendment had been properly and legally ratified. He knew it had not been, but under the law, it was the Secretary of State's job to declare whether a proposed amendment had been passed or not. Notwithstanding the fact that he knew it had not been, he declared the 16th Amendment properly and legally ratified. Let's give a very warm welcome to a national hero, Bill Benson. Whoops. Where's Bill? I thought for a moment he might be over at the White House tacking a 95 thesis equivalent to the front door, but here he is.
No, just this. Thank you, Bob. Thank you, ladies and gentlemen. As always, it is a pleasure to be behind these microphones. I love it. I love to tell you these stories, true stories, stories of my life that I've lived through and gone through, the suffering, the pain that the Internal Revenue Service and this government has caused me, my family. And that's why we see empty chairs here. Because in this government we have cowards that don't want to step forward. They don't have the courage of their convictions to meet us in a meeting room. Tell me where I'm wrong. Show and prove to me and to you that this book, The Law That Never Was, is wrong. There are 17,000 certified notarized documents to back up every word in volume 1 and 2, and they cannot dispute them. I cannot thank Whitey Harrell enough, or our courageous juror enough, by doing what they have done. Because whether the government realizes it or not, it's a huge stepping stone. They're not going to be so quick to indict. As I said here on July the 2nd, 2nd of 1999, that I challenge the Congress of the United States. I challenge the Justice Department. I challenge the IRS. Come and get me. Yeah. Come and get me. I'm the one that you have the fight with. Don't take it out on all these people. Come and indict me if you have the courage to do so. Come and prove volume 1 of The Law That Never Was wrong. Come and show me and prove to me where in the state of Kentucky with this beautiful blue ribbon on seal is wrong. In here on February the 10th of, or February the 8th of 1910 on page 587, there was a vote taken by the Senate. There was 9 senators that voted for the amendment and 22 against it. And I ask everyone all over the country, wherever I speak, and I want this word to get back to that White House, the house of, ill repute, whatever you want to call it. He's turned it into a brothel. Hasn't got the courage to come here to send someone here to debate us. But he can do some of the things that he dares to do. You know why he does it? We let him get away with it. We let him get away with it. No one stands and says anything They all fall, they don't say anything. I guarantee you that I say everything that I do, I can prove everything that I say. I can prove it to you. And it is a little bit unfortunate that in Whitey's case, Whitey knew about it, but I don't remember if they brought it all up. But in the state of Illinois, as a piggyback on the 16th Amendment, but when they were ratifying the 16th Amendment, they changed the wording. Instead of enumeration, they made it renumeration. They went into committee, out of committee, and they changed the wording. Simply can't do it. There are many things that's happened since my last visit here. One of the things is I received a letter on March 5 of 2000 from the man that I've told many of you about. His name is Warren Richardson. He was the attorney for Senator Orrin Hatch, as he told me in 1985. Bill, you cannot permit that book to get into the hands of the kooks out there. This book. You're the kooks. You can't permit it to get into the hands of the kooks out there. And I'll tell you what we're going to do. We will let you print all of the books that you want. You name the number. And then you put a price on the book, and we'll pay you, whatever it costs. And I told him, Warren, you're one of the biggest kooks for making this telephone call, or for my calling you back at your request, and for having this conversation with me. And I says, as far as your offer is concerned, you can go to hell. All right. You cannot buy me, because if you buy me, you buy America. If I sell out to all of you people and thousands and thousands of people that I've spoken to in the last 18 years, my God, I'm the biggest hypocrite God ever created. Okay. And I don't deserve to be behind these mics or talking to anyone, or I don't deserve the applause that I got here when I got on this podium. But I continue to search for the truth. I found the truth, and I speak out about them. Warren Richardson writes on May 5 of 2000, remember, this is the guy that made a bribe, that said you'll be a multimillionaire. You'll never have to worry about another thing. The only thing I said to him, I said, okay, if you free all America from this income tax, then I won't say anything about it. I don't have to, now do I? No, he said, we can't do that, just you. I said, no, that's not good enough. On May 5, Warren Richardson writes, now 16 years later, I have never talked to this man until we were in Cancun, Mexico, for 16 years. He said, you may address me simply as Warren and I'll call you Bill. Thanks, Warren. My first comment is to applaud you on the tremendous amount of work you have done in bringing to light the enormous volume of factual data, over 17,000 pages of certified government documents from each of the 48 states that number in 1913, as well as from the National Archives in Washington, D.C. In fact, the whole project, which included your books, is truly monumental. In case you wish to know a little bit about my background, let me give you a brief overview. I was honored to serve my nation in World War II as a naval aviator. Since my college career at the University of Rochester was interrupted by the war, I went back to the U of R and obtained an AB degree in history. History. This is history. I went back to we went back to Washington, and they had to move back because his wife was studying law. She was going to be an attorney too, and she was in college. And upon reviewing my law degree, when he got back to Washington, I was honored to be chosen for the first class of law graduates at the Justice Department. This program was started in 1953 while Eisenhower was president. Because of my law and accounting background, I moved to the legal department at the General Accounting Office. After 5 years as a government attorney, of years at that time spent in a law firm, he has spent 2 years in a law firm, and then he is now working as a lobbyist. To me, Warren Richardson, and to everyone in this nation, lobbyists are nothing but blackmailers. Before going to the subject of your books, the 16th Amendment to the Constitution of the United States of America was not properly ratified. I wish to lay some groundwork. In 1985, the United States Supreme Court ruled a direct income tax to be unconstitutional in the Pollock versus Farmer Loan and Trust Company, and then he gives a cite. Since our forefathers who established our form of government, and in parentheses, a republic, not a democracy, by splitting the federal power into 3 equal branches, legislative, judicial, and administrative, it was clearly within the court's discretion to render their verdict in the Pollock case. The Supreme Court's decision in that case can only be changed by one of 2 methods. The Supreme Court, assuming it was valid reasoning, could reverse the Pollock court, or an amendment to the Constitution to the United States authorizing a direct income tax could be passed by a vote of 2/3 of both houses of Congress and then ratified by the legislators of 3/4 of the states. By the following procedure of item 2 above, the Secretary of State has the duty of announcing to the public and the President and the Congress that a proposed amendment has been accepted or rejected. Accepted or rejected. How many times have I said the only thing that the states can do in an amendment to any amendment to the Constitution is either accept or reject, no more, no less. They cannot change one word. They cannot change a comma, a capitalization, a period. They can't change anything. And they wrote about that, and I'll read that to you in a minute in Volume 1. Warren says, in my professional opinion, your 2 books demonstrate, at least to me, that the 16th Amendment was not properly ratified, even though the Secretary of the State made the public announcement that it had been properly ratified. When only 4 states of the required 38 states ratified it properly, how could it be considered valid? In view of the facts, how could it be a valid part of the Constitution? Since the Pollock case has not been reversed by the Supreme Court, what is the legal framework upon which the current income tax law is based? Why are we here? We have asked the federal government of this country for these very same questions. What do you base it on? Are we wrong? If we're wrong, show us. I know of no man that has done greater work than Bob Schultz as far as going to Washington, and Joe Bannister. And Joe Bannister in the president's outer chambers of the office, I believe it was the president's legal advisor, hands him his tape. And he said, I shall not file a 1040 tax return. And of course, Joe gave him his background. And you know what? It's all on film. I'm going to send a copy to him. Although I am a lawyer, Richardson writes, it is important to note that I am a constitutional scholar, that I am not a constitutional scholar. It doesn't make any difference. He's a lawyer. Being a lawyer in his capacity that he likes to use as representing Orrin Hatch in making bribes, he also belongs to the American Bar Association. He also has to answer to the Disciplinary Commission for the American Bar Association. And believe me, before I am through, the American Bar Association and the Disciplinary Commission is going to get a complaint both on Orrin Hatch and Warren Richardson. So he's not a constitutional scholar, therefore I cannot speak as one. How can you say the things in this letter you have already said? Incredible. As noted above, it is my opinion that based on your overwhelming evidence that the 16th Amendment was not properly ratified, further, I believe that it is imperative to have legal scholars in constitutional law study this matter deeply and render their opinions on whether the 16th Amendment was properly ratified, providing they come to the same conclusions we do. Thanks, Warren. 16 years it took you to get that through your brain. What is the proper ratification? What would be the logical next move? That last question is a real tough one. No, it isn't. Because of the politics involved. Who gives a hang about politics when a law has been allegedly ratified that has not been ratified, and you don't have to live under it, buy it, throw it in the garbage can? When I concluded the work on the 16th Amendment in 1984, came back with 17,000 certified notarized documents, my code book went into the garbage can and it's still there. Yeah. Assuming that the Supreme Court relies on a case properly brought before it, the tax system of the U.S. is not legal, can you visualize the reaction of the members of Congress? Why aren't they here? We begged and we pleaded. Congress, come and show us where we're wrong. Mr. President, come and show us where we're wrong. And will they do it? Silence. Silence. That's right. They cannot dispute this book, no matter how they try, no matter what they do, they cannot dispute it. And it'll never be thrown in a garbage can. He writes, Bill, you have done a magnificent job in providing the factual data about whether the 16th Amendment was properly ratified. I'm hopeful that we find the scholars who will go to the next step and suggest what we should do now. What have we asked for? What have we pleaded for these last 4 sessions here? What have we pleaded for members of Congress to be here, or any of their staff? Any of the president's staff, anyone they want to send. Do we see anyone? No, no one. What I say, no guts, no glory. Thanks for your hard work. You have done a great service to your country. You bet I have, and I'm proud of it. Warren writes a cute little P.S. Since a personal letter cannot be distributed or even shown to anyone other than the recipient without the permission of the author, I hereby authorize you to show it. I'm going to show this letter to the world, believe me. In parentheses, not publish it. Watch me, Warren. If he would have put it in brackets, now would have been a little bit different. Publish it? No, I couldn't have published it then. But I can show it. I have his blessing to show it. When I was in Cancun, Mexico, giving a speech before 3,500 people, this went on a 20 by 20 by 20 foot screen. 6 of them throughout that auditorium. It was fantastic. So this is the work that we do. This is why I stand with Dick. You bet I'll go to jail again if I have to prove my point. Jail doesn't scare me, not one bit. It scares them. Why do you think they're not here? It scares them, that's why they're not here. And it's going to scare them when charges are filed against them and Warren Richardson got wind of the fact that I was going to file charges against him. That's the reason he wrote this letter. There's no other. Otherwise, he simply wouldn't have written it. In a 16-page memorandum that I found in the National Archives in Washington, D.C., it was a memorandum that was written on February the 15th of 1913, 10 days prior to Philander Knox coming out with his proclamation. And in his proclamation, he said that it appears from the official records on file within the Department that the states have ratified the amendment making it law. It appears. Nowhere, not even to this day, has the federal government said this amendment has been ratified in fact. They can't do it. On page 6 of that memorandum, it says, in the certified copies of the resolutions passed by the legislators of several states ratifying the proposed 16th Amendment, it appears that only 4 of those resolutions, those submitted by Arizona, North Dakota, Tennessee, and New Mexico, have quoted absolutely accurately and correctly the 16th Amendment as proposed by Congress. The other 33 states all contain errors either of capitalization, punctuation, or wording. You can't change wording in any amendment. Minnesota, it is to be remembered, did not transmit to the department a copy of the resolution passed by the legislators of that state. How can they go ahead and count that state? They can't. And here is their excuse of what they did. On page 19, on that 16-page memorandum, 19 is in volume 1, it's 15 of the memorandum. What the lawyer says to Philander Knox, further, under the provision of the Constitution, a legislator is not authorized to alter in any way the amendment as proposed by Congress. They cannot alter it. They cannot change it. I didn't write it. No one in this room wrote it. My scholarly writer over here, Bob Schultz, didn't write it. But they're scared to death of it because they know it's out here and they know I talk about it. That's why they tried to do everything they could and kill me in prison. On page 16, it gives the explanation of Minnesota. The department has not received a copy of the resolution passed by the state of Minnesota, but the Secretary of the Governor has officially notified the Secretary of State that they have ratified the amendment. The Secretary of the Governor? Give me a break. Has no authority to send a certified, notarized document like they had to back to the Secretary of State like this, only theirs would have been in red with a red seal. She has no, or he has no right to do it. It must be the Secretary of that particular state, and only the Secretary. Otherwise, you can't count it. 16th Amendment has caused great waves all over. I am extremely pleased and happy that we have the audience that we do today. And Whitey Harold and Melissa are brave juror. I'll tell you, boy, that is a brave lady and a very courageous lady. She is going to set the pattern. You understand the pattern that jury has set for this country? It is, some people say, no, it's not a precedent case. Oh, yes, it is. What do they say? Show me the law. And that's all I'm asking them to do. That's all Bob has asked them to do. That's all Joe has said. Show us the law. And they can't do it because they don't have it. It's never been ratified, and here is the proof that it has never been ratified. Get by this. And maybe they can get by me, but they can't. How are they going to dispute 17,000 certified notarized documents from the National Archives in Washington? They can't. They can't. Those documents, I don't need the books. I have the documents that are certified and notarized in any courtroom. One of the things that we've heard is make your case before you go to court. That's exactly what we do. The IRS, when you get your first letter from the IRS, you either call me and say, look, I've got a notice from the IRS. What should I do? 30 seconds. Okay, Bob. You'll blow my mind with this thing. I'll eat this up in 30 seconds. You know, he's throwing me with that. So I'm going to read you a letter from a very, very dear friend of mine and a very old dear friend of mine from when I started the work with federal government in 1993 when I put out the Reliance Defense Program. When you get into a problem with the government, you go ahead and you bring things to the IRS. Make it a part of your permanent record right then and there. Now they cannot dispute it. We don't have to bring the records in. Now the IRS has to bring them in. The government has to bring them in. And my very dear friend is here today, and his name is Frank O'Neill. He's a retired doctor. And Frank's wife got into a great deal of problems with the Franchise Tax Board in California. And he says, Bill, help, what can I do? Frank flew me out to California, and boy, did we have fun. I don't think Frank will ever be sorry for that, and I certainly am not, because I gathered another very, very dear friend. The answer to the Franchise Tax Board when they were presented with the 16th Amendment documentation, and only the 16th Amendment documentation, it goes like this. The information provided has enabled us to correct the 1990 and 1991 account. The only information that was provided was this book and many other documents to support. There you go. To support with the Franchise Tax Board. And they're the toughest board to deal with, believe me. The information provided for 1991 account, please disregard our notice billing date. And in a check mark, your account is closed. And we are sorry that we have inconvenienced you. How do you like that? Thank you, Frank. Frank, stand up, please. Frank, stand up. You deserve it. Dr. Frank O'Neill. Shortly after that, they came after, and I know, Bob, I'll be quick. Shortly after that, they came after Frank. Same information was presented to the Franchise Tax Board. It only took them about, I don't know, maybe, I think it was maybe less than 6 weeks to come back with the very same letter that his wife received. We're sorry we have inconvenienced you. Your case is now closed. So, ladies and gentlemen, I rest my case. Bob, thank you for the extra time.
And thank you, Bill. Joe Bannister is the former special agent of the Criminal Investigation Division of the Internal Revenue Service. He undertook at his own expense and on his own time a 2-year research effort to prove that those people who were claiming that the 16th Amendment had not been legally ratified and that there is no law that requires people to file or pay the income tax, and no law that requires employers to withhold from the paycheck of their workers, were all wrong. Joe Bannister set out to prove them all wrong. Instead, Joe Bannister reached the conclusion that those people who were making those claims were correct. He submitted his 90-page research report to his superiors in the San Jose office of the Internal Revenue Service with the request that the report be passed up through the chain of command to the commissioner and that some answers be forthcoming. Joe was simply asking for answers. Instead of getting answers, Joe was asked to resign, which he did in February of 1999. Joe Bannister.
Thanks, everybody. Thank you very much, Bob. And